Good morning, everybody. Welcome to the Contemporary Issue class. What a good turnout today to talk about the shift in the Supreme Court. Ron wasn't sure. Our presenter, Ron, said, might not be anybody. It's July. And look, we probably got 35 people here and 5 or 6 on Zoom. Welcome here to Zoom. Okay, I want to welcome any first timers also. Anybody first time in class today? Nice to have you here. Could I ask your name? Leanne. Nice to have you here, Leanne. I'm Steve, and this is Ron. Present today one of our class members. And but first, our usual announcements. Zoomers, please mute yourself on the lower left corner of your screen. Keep the background noise down. And we are recording this for later playback and save onto YouTube. Folks like to look at these classes presentations often later. And of course, with our topic today, it's another political topic that is controversial. And so when you comment, and we hope you do, please be kind to the other side, because there's two sides to this issue, of course. And but we are really glad for this timely topic today. I was just reading in the news this week a comment by one of the liberal justices, Sotomayor. She said, these new folks on the court who have shifted our court want to be originalist when it suits their desire. So that was a pretty strong statement. So even among the court, even among the justices, there's tension and comments like that. So what a different time we are in. So we are looking forward to discussing this. Any announcements? Anything's going on? Yes, Joy. Okay, good. Active Minds class. There will be refreshments and food, huh? Good, okay. Lots of things going on. I like to plug also the upcoming trip next February that the church is leading to the Holy Land. If you haven't been to the Holy Land, it is an amazing, life-changing thing to go and visit the actual places. And Rev Jerry is leading a trip there. I encourage you to think about going. Okay. With that, Ron, the Supreme Court. Good luck. Good luck today.
Well, I thought the segment of the song was like on first.
Here. Ron, we can't hear you. Why are we so dark? It's even darker.
It's the light coming.
Okay, there.
There's a little one. Glare.
Ron, we can't hear you.
Okay, we'll work on that.
We'll see what we can do.
Okay. You could hear us before, right, Susan?
I can hear you, Steve, just can't hear Ron.
Oh,
We could hear Ron very clear before.
okay, speak.
Okay.
Might be.
Okay. Might be, yeah. On the computer. Yeah.
The owl what?
The owl isn't worth
The owl device. Well.
Now,
Go ahead, Ron.
okay.
Susan, can you hear Ron now?
Say something.
Okay. The song you just heard, hopefully, was written relative to the 1954 ruling, Brown versus the Board of Education. And the song, of course, wasn't recorded and released by the more popular rock group Three Dog Night until the 60s, but it referred to the decision to basically segregate schools. And hence the song Black and White, now child, kids can mix together. The song is called Black and White by Frida White. Okay, alrighty. This is an interesting subject. We could certainly do a whole semester on it. We're going to try to roll quickly, and we're going to try to wrap up with a good bit of discussion on at least 6 of the major decisions that have been released by the current Supreme Court. In this opening slide, we show the current members, and just days ago, June 30th, exact date, yeah. Ketanji Jackson took over for retiring Justice Steve Breyer, who's in the first row, second from the right there. Those are the current 9 members of the Supreme Court. Next. There we go. Here's a cartoon I like, if you can call it a cartoon. Hi, we're here from the place with the God-given right to guns. I thought that was a very ample cartoon. All right, some of the resources around. Book, The Agenda, How a Republican Supreme Court is Reshaping America. And some people don't like, say, you're pushing Democratic stuff. No, the Supreme Court has been taken over by a strong majority of very conservative people. That's a fact. Now, whether you like it or not, that's for us to talk about and decide. But this is a good book that looks at what we can expect from this Supreme Court. And we're already getting a tidal wave, a tremendous surge of actions that you may either like or sharply dislike. Pass that around. We also mentioned in today's lesson, probably the most infamous judge, leader of the Supreme Court, Roger Taney. He was put on the court by Andrew Jackson, and Taney has had his statue taken down from Washington, but he is considered, he wrote the opinion of the Dred Scott decision. We'll mention that. Jackson elected 1824. Then there's another good book, Justice on the Brink, The Death of Ruth Bader Ginsburg and the Rise of Amy Coney Barrett and the 12 months that transformed the Supreme Court. Around. Next. Okay, of course, the Supreme Court, sometimes used by the abbreviation SCOTUS, S-C-O-T-U-S, that means Supreme Court of the United States. It's, of course, the highest court in the federal judiciary, and it has ultimate jurisdiction over all U.S. federal court cases. There, of course, are district federal courts. I should know the number. Is it 9 or 13? It's something like that. But cases that are often passed through a lower federal court often, or at least sometimes, end up getting spilled up to the Supreme Court. The Supreme Court does have power of judicial review, the ability to invalidate a statute for violating a provision of the Constitution. It's also able to strike down presidential directives that violate the Constitution or statutory law. A few historical notes. It was established by Article 3 of the U.S. Constitution. The Judiciary Act of 1789 established the size of the court at 6, Chief Justice and 5 Associate Justice. John Jay was the first justice. The John Marshall Court, which was in the very early 1800s, established the power of judicial review over acts of Congress. And it gave the Supreme Court the ability to throw out, if decided so, some laws that were passed by Congress. Getting back again to the Roger Taney Court, 1836 to 1864, the Dred Scott decision. And the Dred Scott decision said that all people of African ancestry literally anybody of African ancestry, slaves as well as those who were free, could never become citizens of the United States and could therefore not sue. So Tawny's statements are about as racist and unimaginative as you can imagine, hence the book on him. No, it wasn't Supreme Court. The Congress actually, in deciding how many representative states get, decided the slaveholding states could count slaves as a fraction, 5/8. So interesting. One of the more interesting acts of the Supreme Court was Plessy versus Ferguson in 1896. The gentleman on the right there is Plessy. He was 1/8 a black man. That's a pretty small percentage. Nonetheless, he was basically shuttled off a train car for trying to sit with the pure white passengers. He appealed to the Supreme Court and he lost the trial. He lost at the Louisiana Supreme Court and he appealed to the US Supreme Court. And the Plessy versus Ferguson decision decided that racial segregation laws were okay as long as they were equal in quality. Of course, we know they weren't equal in quality. Okay, so there's one of the more controversial ones. 1954, Brown versus the Board of Education. The song we just heard refers to it. Oliver Brown filed a class action suit against the Board of Education in Topeka, Kansas in 1951 after his daughter Linda Brown was denied entrance to Topeka's all-white elementary school. Next. Right. Of course, the monumental decision came out in May 17, 1954. Surprisingly, it was unanimous, 9-0. And the Supreme Court ruled that separate educational facilities are inherently unequal. A movie I highly recommend is one with Sidney Poitier, Separate but Equal. 2-hour movie. But if you want to have a good movie to watch with your family, I highly recommend that movie. It's got some good moral content. It'll make you think as you watch the movie, why did this happen? How did this happen? I remember 1961, driving to Florida with my family, 3 brothers and sisters, my mom and dad, and a Chevy station wagon. And when we were going down the Dixie Highway, this is before Interstate 75 went all the way to Florida. I remember when we entered the grand state of Tennessee, we saw some of these signs. Impeach Earl Warren. Earl Warren, of course, was the Chief Justice of the Supreme Court that put out the decision there in 54 to give equal rights and knock down segregation. All right, next. Okay, we want to talk for just a minute about the tradition, the doctrine of stare decisis. It's Latin. Stand by things decided and not disturb the calm. But in this handout, there's a good explanation, and I encourage you to take it. But I also have highlighted in yellow the comment, legal scholars like to joke that stare decisis is Latin for stand by things decided and it suits our purposes. So if you look at the history, at least several disregarded stare decisis and overruled the processes. So again, it's happened 232 times. So always following precedent has not happened. Good article on that. It's both. It's both. Yeah. Okay. Quick review of our Supreme Court right now. Chief John Roberts, put in by George Bush. This chart shows who put the various justices in, how old they are. Roberts is 67. Second guy on there is Clarence Thomas, very controversial. Stephen Breyer, who's just retired and has been replaced by Ms. Jackson. Excellent. Samuel Alito, a very conservative person put on there by George Bush. He's age 72. Of course, two of the Obama appointees, Sonia Sotomayor and Alina Kagan. You'll generally find these two ladies voting against the current majority. Next. Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. These three have all been put in by the illustrious Donald Trump and have changed the court immeasurably. And we're waiting to see how much more change is coming in, and it is. All right. Rapid shift in court via 3 Trump appointments. We do want to recall that when Obama was in the middle of his term, there was an opening in the Supreme Court, and he was going to put a nominee forward, but the Senate, controlled by the Republican Party, would not even advance his nominee 2 years before Obama's term was in for a vote. So essentially, the GOP-controlled Senate stopped Obama's nominee from even being put forth and said, we're going to wait to the next election. 2 years, yeah. And then, of course, we saw literally weeks. Was it 6 weeks, 8 weeks, 5 weeks before? There, Trump immediately appointed someone, and the Senate, GOP controlled, rushed her through very quickly. It used to be in the 60s, the 70s, there was kind of a, shall we call it a gentleman's agreement, or an understanding that the president appointed someone and you considered him, and you only rejected him if you felt there was really, really some serious flaws or whatever. The vast majority of first appointees put in the 60s, 70s, even 80s were not rejected, and most of them went through by votes of like 85-15 or 90-10. It was kind of again, a gentleman's understanding that anyone but the most extremist should be approved by the Senate. But now it's a whole new game. Now the Supreme Court is viewed as a extremely partisan kind of person, and there's no holds barred bringing in Supreme Court appointees. Supreme Court, of course, the appointments are for law. And you have to have the president of your party to get somebody. And the Senate now has ability to really essentially block any appointment. So to really successfully get through a Supreme Court appointee now, you've got to control the presidency and the Senate for all practical purposes. Right. There's some doctrines that are hovering. The court has signaled it intends to use the non-delegation doctrine to roll back access to health care. There was a case in 2020, which is pretty recent, called the Little Sisters. I think that's the Little Sisters of the Poor versus Pennsylvania. SCOTUS considered a provision of the Affordable Care Act allowing a federal agency to determine which forms of preventive care and screening for women must be covered without copays. And the federal agency determined that contraceptive care must be covered. But Justice Alito's opinion on this issue suggests that the Supreme Court may strike down the requirement that health care insurers cover birth control. And it may strike down other provisions of Obamacare requiring coverage of immunizations and pediatric. This hasn't happened yet, but we can see the move toward it. Good example is Hobby Lobby, a little cartoon there. Hobby Lobby is extremely contentious regarding the rights that it gives employees. And it does not like giving its employees birth control and many other healthcare rights. Next.
Clear. Their employees, their premiums. They're still paying for their own contraception. It's not coming free. It's not that. So it's not free. So
Okay.
just
Okay. We're going to reach back in history. The 1968, there was a gentleman in South Carolina that built one of the biggest pork barbecue franchises in the country. And in an issue called Newman versus Piggy Pork Enterprises, SCOTUS ruled, again, this is 1968, SCOTUS ruled that religion could not be used to immunize a business owner from an anti-discrimination law. Maurice Bessinger, who's shown in this picture, sold white supremacy tracts. He had a big open rack as soon as you came into South Carolina-based pork barbecue restaurants. And they not only sold the tracts, but offered a discount on food to those who bought them. But when he lost the Supreme Court case, he put up a sign, get a load of this, proclaiming, "The law makes us serve ends, but any money we get from them goes to the KKK." All right. This was in South Carolina. And he's got a book on sale, even now, I think it is his barbecue, Defending My Heritage, Growing Up Southern. And he sells that book at his restaurant. At any rate, also at Fremont Christian School in California, there was a very conservative group there where they said, the husband is head of the household. Therefore, we do not offer health insurance to married women employees if they have a husband who's covered, because it's the husband's responsibility to care for the wife. Therefore, sorry, women, you don't get our insurance. Believing it was the husband's job to provide her with such health benefits. The case didn't reach SCOTUS, but you can't do that now. But it does give you an idea what some of the more fundamental religious groups have tried to do relative to healthcare packages and rights for women, particularly birth control, contraception, abortion. Okay, so what's going on right now? There's been 4 religion cases this term, and basically we're seeing the new court supporting, for example, the football coach's prayer at a public school football game, and allowing parents to use Maine's tuition grants for religious school tuition, requiring Texas to permit a spiritual advisor to pray over death row inmates, and siding with a Christian group that wanted to be among private organizations allowed to fly its flag. So I'm not going to go through those 4 issues, and I have different opinions on each one of those. And I'm not against, yeah, you got to protect religious rights. But it looks like the current court is going to really try to move the bubble far more to the protect the religious group. Yeah, there are almost 6 or 7 of them are Roman Catholic. Yeah. Okay, other things where it's likely It's likely that the court will hold that business owners have a constitutional right to defy at least some anti-discrimination laws. For example, there was the baker here in Colorado said, I will not bake a cake for an LGBTQ couple. So this is an issue that's going to get pushed on in the next couple of years. You can count on it. The Supreme Court warned nearly 150 years ago that a system that allows doctrine of religious belief to be superior to the law essentially will make every citizen law unto themselves. We certainly don't want it to go to an extreme where someone could say, well, I don't like American Indians, therefore I'm not going to have anything to do with them. I'm not going to hire any of them. I'm not going to get, that kind of thing. So we have to be careful. Things can really move in that direction, and religious freedom can be used to do some incredible amounts of discrimination and persecution of others. Okay, next. So there's one area, religion, that's going to change quite a bit. There's the goal of dismantling the administrative state. There's likely future presidents are likely to find their ability to protect the environment, expand access to health care, and ensure fair wages is going to come under pressure, and it already is. Supreme Court handed down an unexpected order announcing the EPA's guidelines for electric utilities was staying. Electric coal-burning fire plants put out, I think, 30 or 40% of all the CO2. So there was a law put in EPA saying you got to start phasing out and cutting back the pollution levels from these coal-fired power plants. And the ability to do that is now getting crippled quite a bit. The good news, coal is, there'll probably never be another coal power plant built, but it looks like a lot of existing ones may definitely hang on a lot longer otherwise. Okay, Congress gave the job of figuring out the best system of emission reduction at the particular time to the EPA administrator when he created the Clean Power Plan. Steve Bannon spoke of deconstructing the administrative state and not delegating power to agencies. So there's definitely, it's happening right now, that the ability, and we'll talk about a specific decision, but it looks like the president's ability to, Congress's ability to delegate authority to the EPA and some other federal agencies is already getting cut back. Okay. This decision just came out, said the court said we will only allow rules approved by a supermajority. This is called the major questions non-delegation doctrine, says that major issues must be explicitly authorized by Congress, that authority cannot be delegated by the legislative branch to executive directed agencies like the EPA. So this really throws a wrench in the gears of the ability of EPA and other federal agencies to address things. It says the legislature has got to roll through and make all these major decisions, not the EPA. And because the legislature is so gridlocked right now, it's going to cripple a lot of the ability of the EPA. one of the handouts you've got is gridlock in Congress has amplified the power of the Supreme Court. On the second page, by insisting that can promulgate a significant climate rule only by showing clear congressional authorization at this time, when the court knows that Congress is effectively dysfunctional, the court threats the upland and responsibility to safeguard the public health and welfare. So they're saying, let's not let the EPA putting these rules. You got to have the full legislature, House of Representatives and the Senate make these moves. So yeah. So the ruling states that major issues cannot be delegated by the legislative branch to the executive branch, which is where the vast majority of the agencies reside. So this is bad news. There's going to be a lot of litigation on that. Okay. So the Clean Power Act of 2015 is one of the things that really has been crippled by this. It had the power to reduce CO2 emissions by 32% compared to 2005. The Trump administration basically said that the states create their own rules for existing coal-fired power plants, not the EPA. Of course, state of West Virginia, lawsuits for obvious reasons. Okay, next one. All right, now here's one that scares the bejesus out of me. Moore versus Harbor, independent state legislature. And this is one coming up. The Supreme Court is going to decide, and I'm really biting my nails on this one. The current rule says each state shall appoint in such manner as the legislature thereof may direct a number of electors. States have interpreted legislatures to mean the state's general lawmaking process, meaning the governor, the legislative bodies, and the state Supreme Court. Now a radical minority insists that legislature alone has the full power, unchecked by state courts or state constitutions that prevent gerrymandering. There's been a couple gerrymanders, horrible gerrymanders that have been stymied by a governor or the Supreme Court of state. Cases in point, North Carolina, Pennsylvania, and some others. But if the Supreme Court rules that the legislature has power, it can mean phenomenal gerrymanders, even throwing out the state's election results can happen. A state controlled, like let's take Ohio, for example. The Republican Party has nearly a supermajority in both of those bodies. Just say, well, we don't like how our people voted. There was obviously, fraudulent votes. We're going to throw out our slate of electors and appoint our own. So this one really scares me. Moore versus Harper case comes from North Carolina, where the state Supreme Court rejected a dramatically partisan gerrymander, which the Republicans say the state court cannot stop because of independent state legislature. This would strip power from the elections commissions, secretaries of state, and take the state's court's power to challenge gerrymandering. So look out, here it comes. In fact, there's even an article this week, one that just came with, who's on the cover, Boris Johnson getting tossed out. There's an article in there that specifically talks about this thing that scares people to death. Okay, we're going to wrap up by looking at six key decisions this term. Climate change, the EPA has been significantly curtailed. from regulating emissions from power plants. Again, that was West Virginia versus the EPA. Church-state separation, that was the one dealing with religion, permitting the school coach to hold prayers on the field after games, and the main funds to religious schools. And of course, the third bullet I've got on here, abortion rights. Next. Here's a cartoon I like. Your tax dollars at work. We'll get to our math lesson in a moment, class. But first, let me tell you about Jesus. And Justice Sotomayor in the Carson versus Macon dissent said, this court continues to dismantle the wall of separation between church and state that the framers sought to build. Today, the court leads us to a place where separation of church and state becomes a constitutional violation. So she's not, yeah. See what happens. Here's three more, the Miranda rights. This limited enforcement of Miranda rights, saying suspects cannot sue a police officer for failing to warn them of the right to remain silent. Innocence, remove constitutional right to present new evidence in federal courts, to argue for inadequate representation. And then, of course, gun rights. You've probably all heard of the laws in the city of New York that have been where people have to show a need and a good reason to be able to open carry firearms in New York. That's been thrown out. So gun rights are in for a real change. Yeah, I've talked, my final slide before we get into some more discussion. Enforcement of rulings. Supreme Court cannot directly enforce its rulings. Instead, it relies on the Constitution. And the most famous one was where Andrew Jackson ignored the Supreme Court's decision in Worcester versus Georgia. And he made the statement, John Marshall has made his decision, now let him enforce it. He refused to protect the Cherokee Indians from displacement. So this is interesting. All right. Yeah, let's get into it. So like it or not, these are some of the things that are happening. What was another one? There's also strong feelings on allowing extra rights and certain law schools and stuff. There's some significant challenges right now. So you shouldn't put any extra blacks or people of another race into any competitive situation. It should be strictly evaluated criteria. That's another thing. Clearly, this is a decisive moment in American history. Let's face it, rarely, if ever, been this tipped to one side. Yeah, yeah.
Zoomers, can you hear the comments? You can't at the moment. Okay. On our owl here. Excuse me for just.
I should have very separate and independent people. It's a fantasy.
Now we can hear Ron.
Can you hear Brian? Can you hear better? You hear?
When you talk through the mic.
Can you repeat the questions or comments?
Okay. Jim Watson made the comment that he felt strongly that the court should not be conservative or liberal, but should have very intelligent, centrist, neutral thinking people. Make it, want to see it swing either way off the middle of the dial.
Doing their own agenda, conservative agenda, or this is just, or this is the way. Anybody disagree?
Can you imagine being in Elijah Kagan's shoes or Sotomayor's shoes, having to show up every day, and hearing this rumbling from people saying the Supreme Court has no legitimacy anymore, and that's, they're very dedicated to it. Terrible catch-22 for them. Yeah. Absolutely.
Susan, can you hear us now?
Maybe it's because I'm at the beach.
All this tripping.
Jim says the Supreme Court is not subject to any oversight. Bad to have.
Cannot be correct. They're so far.
But of course, they say the new ones say that. So how do we change that? Oh, Ann, you have your hand up. Go ahead.
I don't know if it's just me online, but I can't even hear you hardly now. And for sure, I can't hear the responses. other people. I know technology, it can be challenging and it may
Yes.
be just something that we can't listen to today online.
Yep. Sorry. Get it better. We thought we had it. Well, what can we do?
Congress could pass some laws dictating, making some changes in terms of setting term limits. Or one person said we ought to let each president each term appoint 2. And then you get to maybe go for 10 years and then you get dropped off, something like that. The difficulty there is the Senate is so imbalanced that it looks like an almost impossible dream. I think it would. Bob said,
That is a different question. Someone's gonna be killed. And I was saying it's full. And
Talking about father has
accountability to help them. There are two people there. I don't know whether you want to call. I can later, I would.
I gotta put in a plug. Harvey Mark made me do it. No, he didn't. But Harvey really enjoyed Richardson's historian's newsletter. This is a 4-page excerpt from from June 30th. And I thought it did a real good job in 4 pages and touching on a wide spectrum of things we've mentioned here this morning. So I encourage you to read it.
It says interesting that Jews define life as beginning when the first breath is taken versus conservative Christians who say life begins at conception. Yeah. Jim. Make the fathers pay, right? Yeah. Yeah.
And I love that, but it's not, but that's only a start. Because anyone who's had a child, or had a niece or nephew or a anyone who's raised a child in any capacity knows it's not just financial, it's the everyday, emotional, physical, intellectual, everything that you pour into the care for that child on a daily basis.
And so yes, the financial responsibility is a place to start, but who's going to actually raise that child? And those who say, oh, there are many people wanting to adopt, just go look at the number of people in the foster system right now, children who have been waiting for years and have no family. So until that number changes, and everyone who says, oh, a child is precious and must be taken and loved, and then does that, I think that it's very hypocritical.
Well, I'm sorry, but I'm not talking about just financial.
No, okay, good. I'm glad to hear that, because a lot of people do. They just say, oh, they, child support, financial child support. So thank you, I'm glad that you agree.
I heard a study reported just this week that said it costs $19,000 to have a child.
Anybody think the Supreme Court has a hard job to try and balance between all the competing desires? Or do you think it's an easy, simple decision they have?
It's easy, they've already made their minds up.
They've already.
And it's not like this is a starting point. They've been judges for many, many years, so they're used to the process. I mean, I guess where I'm going with this is that when somebody starts out and wanting a law degree and moving on up through the system, they're going to be aware of both sides and what the job is when they want to take part.
My fear
is that they are going to use this, they're going to use the Constitution to interpret it in such a way that we will have a white, male-dominated, minority-ruled government. And they're going to throw in Christianity, and impose their particular brand of religion on the rest of the country, even though it's clear that our founding fathers didn't want that. But our founding fathers, we did start out as a white, male-dominated, minority-ruled government.
Right.
In the 1776. So when they say go back to 1776, they're originalists in that way. And that's my fear, that they will move us in that direction and forget about multiracial democracy. I mean, I feel that these justices, the conservative justices, really don't care that much about democracy.
One of
as
the
we know it
conservative
today.
justices is Amy Coney.
Yeah.
She's a female.
But
You're in an adversarial, you're taking an adversarial stance here, and I'm objecting.
well,
Amy Coney Barrett is a female.
yes, but she adheres to the male-dominated
Oh,
society.
no, she is a person.
Okay. Well,
She is
I
a
stand
justice of the
corrected on
United
that.
States Supreme Court.
but this is what I think the Federal Society, that their idea of a good government is. I mean, let's face it, I'm not against male, I'm not saying that the male-dominated government is wrong, just saying that many people think that that's the way we should go.
I'd like to throw this thought out that I look at the demonstrations, I look at the unrest, I look at the impression I have that much of America is not feeling that they can trust our institutions, our leadership, prices of gas, economics, and so forth. That I'd like to think that some of this is the last just gasp of white America, and we're moving more toward global births. Look at the birth statistics. Whites are not having the births that other ethnic groups are having. And I taught in some interesting schools, and most of my students had a different skin color, even if they're all like Hispanic. The color of the skin was different, and we discussed this one day. And that there's so many different strains of experience and history and culture that I think that Trump, in a sense, was, king of the mountain, and he's going to get shot down. Not him personally, he might even run again, but what he stands for, it is shaking the foundations of how we look at America and the world and our place in it. And so I'm hoping that, to say something more positive like Christianity, as you pointed out, that maybe the Lord is still listening in and gets what's going on. Just metaphorically. That maybe something very strong will come out of this, and we may not live to see it, but I'd like to think it isn't taking down all the positive things that exist in our way.
I'm gonna put in a plug for a lesson I'm working on now that I hope to do in August perhaps, or certainly September. Why Cities Lose. And this book examines how and why, what structural and geographic things are in effect that has enabled a minority to basically get major control with things like the Senate, Supreme Court, even the Electoral College it's going to look at what's caused it, what's allowing I call it the rural whites to have amplified power far beyond their numbers. And it's ruling a roost and pushing the majority aside.
We're about out of time. Any final comments?
James Webb.
Try, yeah.
Okay, let me do a quick prayer before we go. Just say, Lord, please be with our Supreme Court, all of our leaders, and help us to do your will and lead us to be a nation of all people. Amen.
Amen.
Thanks for coming. See you next week.
Elsa, thanks for being with us. Sorry about We'll work on
Maybe I should write it down.
It's the real.